come please to page 12 in the bottom right-hand corner behind tab 2.
Page 12. This is in the rules?
Yes, it is.
Yes, I have it.
So I asked you before the break something about the objects, and I'm now asking you something about the matters set out on page 12 in the bottom right-hand corner, role and composition of the Committee of Management. Now, Rule 15 stipulates that the affairs of the association are to be managed exclusively by a Committee of Management. Was there any Committee of Management of the association that you were aware of when you were drafting the rules?
When I was drafting the rules, I understood that in an incorporated association there had to be a Committee of Management.
And who was the Committee of Management?
I didn't turn my mind to who would fill those positions. That was a matter for Mr Blewett and Mr Wilson.
Was there a president of the association when you were...
I played no role in the... had no role, no connection with who would play what role within the association. That was a matter for it and its members.
Well, did you give advice about that matter?
I would have explained that an incorporated association has members, that there's a minimum number of members, that you have to have a Committee of Management, and having explained those things would have left it to Mr Blewett and Mr Wilson to work out how they wanted this association to work and who should play which role. That was a matter for them.
Did you make an inquiry of them as to whether the offices in the Committee of Management had been filled?
No, I did not.
You have a definite recollection of not asking anything?
I provided the advice and assistance on the incorporation. Beyond that, what the association then did, who were members of it, who served in which capacity, was a matter for them, and I made no inquiry about it.
Did you make any inquiry as to whether there'd been any meetings of members or the like?
No.
Did you make any inquiry as to whether there was a register of members as provided for in Rule 13?
No, I didn't. I viewed it entirely as a matter for them. My role was to provide advice to assist the incorporation. I did not have some ongoing advisory role in relation to the workings of the association.
Well, as I understood it, your role was not simply to assist with the incorporation. You, in addition, were giving advice about the setting up of the association. Is that right?
Setting it up in the sense of incorporating it, not setting it up in operation. That was a matter for them.
Well, perhaps we should go to the application form. It's at page 7.
Page 7.
Behind tab 2.
Behind tab 2.
Now, the handwriting, well, some of the handwriting on this page is your handwriting.
Yes, it is.
So, for example, the black ink Australian Workers Union Workplace Reform Association.
Yes, that's correct.
That's your handwriting, and likewise in paragraph 2, section 41E of the Act is your handwriting.
Yes, it is.
Now, starting at the top of the page, the words in blue ink in capitals, is that Mr Blewett's handwriting?
I don't recall Mr Blewett's handwriting, but given it's Mr Blewett's name, I think it's a reasonable assumption.
Well, was that filled in your presence?
I don't have a recollection of sitting around filling in these forms, so either it was filled in my presence, or I completed some parts of the forms and handed it over to Mr Blewett and Mr Wilson to complete.
Well, do you recognise any of Mr Wilson's handwriting on this document?
I wouldn't recognise Mr Wilson's handwriting after all this time.
Paragraph 2 states development of changes to work to achieve safe workplaces. Did you suggest that wording to Mr Blewett?
No, I did not.
Well, did Mr Wilson suggest it in your presence?
I don't recall that happening, no.
Mr Blewett is not the sort of person, on your memory of him, who would have come up with those words himself, is he?
I think it's possible. I don't see why it's impossible.
Can we go back to paragraph 1? It reads, I, Ralph Edwin Blewett, with an address being duly authorised by the association, apply for incorporation of the association under the name, and then you've written out Australian Workers' Union Workplace Reform Association. Who came up with that name?
When I received instructions about this matter, as part of those instructions, was given the name. I don't have a recollection from the time, but having had the opportunity, Mr Stolger, to look at the material provided to the Commission, I think Mr Wilson says in his statement, doesn't he, that he came up with the name?
Well, I'm asking about your recollection, not anyone else's.
20 years on, or best part of 20 years on, I don't recall. I believe it would have come to me in the instructions for putting the association together.
Instructions
incorporating the association, to be more precise.
Instructions emanating from Mr Wilson and Mr Blewett?
Correct.
Now, they were your client, were they, for the purposes of this matter?
Yes, that's true.
And they were giving you instructions in their own personal capacities?
Yes, that's true.
And you took instructions from them, or one of them, to the effect that the name of the association would be Australian Workers' Union Workplace Reform Association?
That's my best recollection after all these years.
Did you check to see whether the National Executive of the Union had authorised the use of its name?
No, I did not.
The Union was a client of Slater and Gordon's?
Yes, it was.
You accept
well, the Victorian branch of the Union was a client of Slater and Gordon's. It's not my recollection that we ever acted for the National Office.
Was any reason proffered to you for the use of that name by Mr Wilson or Mr Blewett? That is to say, more particularly the use of the name Australian Workers' Union, incorporating those words into the name of the association?
I don't recall a conversation dealing with this matter. I would presume that it had Australian Workers' Union in it because the team of officials, the association, was to be involved in elections in the Australian Workers' Union.
But the point of the association is it's not part of the union, isn't that right?
That's correct. In this sense, that
union monies can be kept in the account operated by the association. Non-union monies can be kept in the account operated by the association.
To finish your answer, Commissioner.
Yeah.
Is there something more you wanted to say to the panel?
I think Mr Stolger and I are on the same point, that it's not proper for union monies to be used to finance union elections. So certainly my understanding of the association was that it was not part of the union, because if it had been part of the union, then it clearly couldn't play a role in union elections. I might have put that in a somewhat circular fashion, but I must have conveyed the meaning.
Yes. But did it cause you concern, the use of the name, the name of the union within the name of the association when those instructions were given to you?
I had no cause for concern at that time.
It's misleading, isn't it?
In what sense?
Well, it suggests that the association is a part of, or authorised by, the Australian Workers' Union.
There was nothing in any of this back at the time which caused me to conclude in any way that the name of the association or anything else about the association would be used to mislead people.
I'm not suggesting that you knew at the time that the association was going to be used to mislead people. I wasn't putting that to you, Ms Gillard. I'm simply saying, did you have some concern at the time that use of the word Australian Workers' Union could be potentially misleading?
No, I didn't have that concern.
For example, use of that name could facilitate, potentially, cheques being drawn in favour of the AWU being deposited into the association's bank account.
Well, I didn't turn my mind to that because I had absolutely no reason to do so, absolutely no reason to suspect that that would ever occur.
Well, did you have reason to suspect that there could be just some general confusion between the association and the union?
No, I did not.
Do you accept now that it would have been, looking back, it would have been appropriate for you to go to the AWU and Slater and Gordon's client and say, look, has someone given authorisation for the use of your name in respect to this association?
None of us get to go in a time machine and go backwards. Obviously, if one got to do the whole thing again, you would do things differently given what I know now that I did not know at the time.
It would have been simple enough to say to Mr Blewett or Mr Wilson, look, go and get a resolution from the National Executive of the Union and come back to me when you can show that this has been authorised by the National Executive.
Well, I didn't have cause to give that kind of advice. I received instructions on incorporating an association. I had the name, the full name, Australian Workers' Union Workplace Reform Association, and I did not turn my mind to, had no reason to turn my mind to, whether or not at any point that would mislead anyone or be confusing or any of those things.
You're familiar with Section 8 of the Act, if you go to 223.
Section 8 of the Incorporation Act.
Associations Incorporation Act.
Associations, yes. So we're back under tab 8.
Tab 8.
Section 8. Yes.
And 8D, well, Section 8 generally regulates the use of certain names, including in D, there's a proscription against the use of a name identical with or likely to be confused with the name of any other body corporate or any registered business name. Did you give any consideration to that when you were receiving instructions about the name of the association?
After all these years, Mr Stolger, I don't recall reading that section or turning my mind to that section, but clearly I was not of the view that this was a name that would confuse.
Now, if you just keep one hand on the Act and come back for a moment to the application, in paragraph 2 you've inserted the word Section 41E of the Act, and that is a reference to Section 4. And 41E refers to an association having more than 5 members and being formed at little e for political purposes. Now, if we go back to the application, that was your apprehension at the time, was it, that the association was formed for political purposes?
Well, given the descriptions in 4.1, that must, at the time, have seemed to me to be the best summary description.
And then paragraph 3 stipulates that the association is not formed for the purpose of trading or securing a pecuniary profit to the members from the transactions of the association. Did you give any advice to Mr Wilson or Mr Blewett about that paragraph?
I don't have a recollection of specifically giving advice about that paragraph, but given my instructions that this association was about a team of officials, trade union elections, fundraising from payroll deductions, raffles and the like, there was no need to particularly focus on that. There was no suggestion in any of my instructions that the association would be trading or seeking to secure a profit.
And then
in that commercial sense of profit.
4 refers to the rules of the association being attached. Those are the rules that you had drafted and we've gone to a moment ago. And then there's a date and a signature. Was it signed in your presence?
Sorry, Mr Stolger, I've just got confused in the documents. Where are you back to now? You're on...
Application, page 7 in the bottom right-hand corner behind tab 2.
The application. Okay, yes, back on the application. So where you've got the prescribed fee is tendered herewith.
Yes, and then there's a date and a signature. Appears to be Mr. Blewett's signature.
Yes.
Did he sign the document in your presence, or do you not remember?
Oh, I don't think so.
Well, you say you don't think so. Do you have a memory one way or the other?
Oh, I don't have a clear memory one way or the other, but I don't think so.
Paragraph 1, just going back to that for a minute, says that Mr. Blewett, being duly authorised by the association, applies for incorporation. Now, there was no association in existence as at 22 April 1992, that's correct?
There was no incorporated association, no.
There was no association at all.
So there was authorised by the people seeking to become this association.
Well, my question was, as at 22 April 1992, there was no association, was there?
No, there was a combination of people who wanted to incorporate an association, was my understanding.
Well, you'd spoken to Mr. Blewett and Mr. Wilson about it, but there was no association, whether formal or otherwise, in existence as at 22 April 1992. That's right, isn't it?
My understanding is that there was a group of people who were connected to each other in the sense that they had come into the Western Australian branch of the AWU as part of Mr. Wilson's move into the branch as part of his team, and that this association was for them to be members of. So I believe there was that kind of combination of people. If you're asking me more specifically than that, that's what my belief was.
Well, you had seen no minutes of any association,
no,
for
I
example?
Had not. No, I had not.
You had not seen any minute of a management committee meeting?
No.
And so far as you know, there'd been no resolution passed authorising Mr. Blewett to apply for incorporation?
No, and I would have viewed all of that as a matter for Mr. Blewett and Mr. Wilson, as I indicated to you before.
Could you come
short adjournment.
Could you come to page 8, which is the certificate?
Page 8, yes, I have it.
Now again, Mr. Blewett, it would appear, has filled out the first two lines, and then it says, that Mr. Blewett certifies I'm the person authorised to apply for incorporation of association under the name, and that's your writing again?
Yes, in the subparagraph, the little Roman numeral 1.
Yes,
that's my writing.
I meant to indicate the writing in black ink, Australia Workers Union - Workplace Reform Association.
Yes, that's my writing.
And your writing, I'm sorry, I withdraw that. Does your writing appear anywhere else on this page?
No, it does not.
And do you recognise the writing in subparagraph 3?
No, I don't recognise it, no.
Was that advertisement date inserted when you completed the writing in subparagraph 1?
I don't recall.
Did you consider whether the association had more than 5 members when you were looking at this document back in 1992?
I would have provided advice that it needed to have more than 5 members.
You say you would have done.
Yes.
You mean in the ordinary course of your practice you would have done that?
In explaining what an incorporated association is, I would have explained the minimum membership requirements.
But do you have any particular recollection of doing that, or do you simply say that would have been your ordinary practice?
That would have been my ordinary practice.
Were you aware when... Oh, I'm sorry, you said you had no recollection of whether the words in subparagraph 3 had been inserted when you completed subparagraph 1, was that correct?
That's correct. And it goes to the conversation we had before the short adjournment. I don't have a clear recollection of meetings, discussions about this matter. We're obviously in the position where we've got the documents and that can assist. Looking at these documents, I'm not in a position to tell you whether I filled in sections of them and handed it across to Mr. Blewett and Mr. Wilson to then complete and go and file and the rest, or whether we sat and did this together. I don't have a recollection of that.
All right. And do you have any recollection as to whether you were in Melbourne or Perth when that was done? Or your work in relation to these documents was done?
The best I can answer you about that is I was not routinely in Perth. In my practice at Slater and Gordon, I did not routinely travel interstate. My life living on an aeroplane was at a later stage of my life. So whilst, yes, I went to Perth on a few occasions for legal work, I was not routinely in Perth.
The documents were in due course lodged for incorporation at the Office of Commissioner for Corporate Affairs. And indeed, one can pick up the date on which that occurred by the date stamp on page 8. Did you have an involvement in the lodging of those documents?
No, none.
Who did?
I presume Mr. Blewett.
Well, you had some further discussions with him over the next month or two about the lodgement, correct?
Do you mean in the sense of the inquiry about whether or not this was a trade union? Yes. Yes, that's right.
And did you discuss with him then the fact that he had lodged the documents?
Well, he must have lodged the documents. I don't recall a discussion about lodging the documents, but obviously the inquiry could only have been made by the Commissioner if the documents had been lodged.
The lodgement, as we've seen, needed to be more than 1 month and less than 3 months after the advertisement. Did you give any advice about that matter, do you recollect?
I thought we had that discussion earlier. I don't recall giving any advice about the advertisement, and I don't believe that I drafted it.
Well, I was really just asking about the timing, but in any event, that's your evidence. Now, did the Office of the Commissioner for Corporate Affairs then contact you?
Once again, my view about this is informed by the documents. If I hadn't seen the documents, I'm not sure I would have recalled these matters, but it's evident on the documents that some inquiry was made, I presume, of Mr. Blewett about the nature of the association and whether or not it was a trade union, and that was then referred to me.
Right. Do you recollect how it came to be referred to you?
No, I don't.
I'll come back to that in a minute, but I just want to ask you about an invoice which appears on page 18.
Of the same section?
Yes. Now that was the first invoice issued by the association to TEAS on 30 April. I'm sorry, the due date was 30 April 1992, so it was presumably issued at some point leading up to that date. Did you have any discussion with Mr. Wilson about the fact that the association had issued an invoice?
No.
Did you have any discussion with Mr. Blewett about the fact that the association had issued an invoice?
No.
You were advising in relation to the incorporation of this association, and it had, prior to its incorporation, already started to issue invoices.
I didn't know anything about that.
No one raised that with you?
No one raised it with me.
The invoice makes reference to a PO box that was set up in Northbridge, WA. Did you have any discussion with Mr. Wilson about that?
No.
And then, again, before we get to the dealings with the Commissioner for Corporate Affairs in WA, if you come to page 20, it's a little hard to read the numbering.
Page 20?
Yes. The association on the 4th of May, describing itself as AW Workplace Reform Association Inc., applied for a bank account. And the signatories on that application, as appears on page 21, were Mr. Blewett and Mr. Wilson, describing themselves in the paragraph headed official position as Secretary of of the committee, it looks like, and committee treasurer. Did Mr. Wilson have any discussion with you about that?
No.
Mr. Blewett?
No.
Now, you wrote to the Office of State Corporate Affairs in WA on the 13th of May 1992. That letter has not been located, but that would appear to be the case from the correspondence which is on page 23.
Yes.
Do you have any recollection of the content of your letter of 13 May 1992?
I don't have a recollection, Mr. Stolger. What I gleaned from these documents, having them in front of me now and obviously having them in front of me during the course of this Royal Commission, is that there must have been an inquiry about whether or not the association was a trade union, and I responded to that.
Well, you wrote arguing the case for incorporation, that's right?
If I'd received an inquiry about whether or not this was a trade union, I would have responded it was not a trade union. That is it. I presume the inquiry from the Office of State Corporate Affairs was this a trade union? Because that would have implications as to whether it should be incorporated as an association or its corporate personality would be governed by state industrial relations law.
My question was that you wrote to the Commission of Corporate Affairs arguing the case for incorporation. Now, is that correct?
I would have done what solicitors do, which is I would have referred to my client's instructions and would have explained my understanding of the law. And my understanding of the law and my client's instructions were that this was not a trade union.
I'll come back to this letter in a moment, but if I take you back to the record of interview, page 137.
Oh, sorry, in the same document though, aren't they?
Tab 3.
Yep, that's right. Yes.
Mr. Gordon says, Slater and Gordon,
Sorry, where are you?
page 137, middle of the page, paragraph beginning and last Monday, third line says submitted those rules to the relevant Western Australian Government Authority. Indeed, that passage suggests that Slater and Gordon submitted the rules to the relevant Western Australian Government Authority. Does that remind you that Slater and Gordon
Slater
had some role in lodging?
Slater and Gordon did not submit the rules to the incorporation body. Mr. Gordon's misphrased that question.
All right, and then Mr. Gordon goes on, there'd been a letter back from the authority suggesting it might be a trade union, therefore ineligible for incorporation under that legislation, and then says, we had prepared a response submitted on Wilson's instructions to that authority suggesting that in fact it wasn't a trade union and arguing the case for its incorporation. And then you say I wouldn't want to be held to the dates, etc., but that accurately summarised, didn't it, what had occurred. A response was submitted on Wilson's instructions suggesting it wasn't a trade union and arguing the case for its incorporation.
I think we're in agreement, aren't we, Mr. Stolger, that I did what a solicitor does, put my client's instructions and put my view of the law.
I understood that you were resisting the proposition that you'd argued the case for its incorporation.
I just think I've used a more accurate description.
Can you come back to the letter on page 23, behind tab 2? Now that letters addressed to you at Slater and Gordon, and says, "Thank you for your letter of 13 May. The explanation which you have provided in relation to the purposes of the association is accepted. However, it's believed that the matter does need to be clarified by the amendment of the association's rules to include new Rule 3 capital A." Do you recollect what the explanation that you had provided in relation to the purposes of the association was?
As I explained earlier, I don't have a recollection from all those years ago, but having had the opportunity to look at these documents, what appears clear on the face of the documents is there was an inquiry about whether or not this was a trade union. I responded to it. The personnel, Mr Neil, the Assistant Director of the Office of State Corporate Affairs, then said that there should be an amendment to be known as New Rule 3A, and then the document appearing on the next page of the folder details what that rule is. And it is to clarify that the association is not doing the kinds of things one would associate with a trade union.
Well, had you crafted the new Rule 3A and included it in your letter of 13 May 1992?
I don't think so, and I don't think that's the sense of this letter. I think the sense of this letter is that the State Corporate Affairs people are recommending that amendment.
Well, where was... The letter on the next page is a memorandum from yourself to Mr Blewett of 21 May 1992, so sometime after this letter. Do you say that the Office of State Corporate Affairs included a version of what actually became Rule 3A in their letter of 15 May 1992?
Well, I think we're both in the unhappy position we don't have the letter of the 13th of May 1992, which may answer this question for us. My reading of the letter of the 15th of May is it may well be that the Office of State Corporate Affairs suggested that draft as clarification, but whichever way, the purpose of the clarification is to exclude the possibility that the association is undertaking work normally associated with trade unions.
The letter of 15 May continues, "In order to avoid any unnecessary costs and delays, the Commission is prepared to incorporate the association with the existing rules annexed to Mr Blewett's application, subject to receiving a written undertaking that the association will amend its rules to include new Rule 3 capital A within 30 days of being notified of incorporation."
Yes.
And you then sent the memo to Mr Blewett, to which you've already made reference. It's at page 24. You drafted a letter that he would be able to send to the Office of State Corporate Affairs.
Yes, I did.
And you were recommending, or at least you were proposing to him to write saying, "On behalf of the association, I undertake that the association will amend its rules within 30 days of being notified to include the new Rule 3A." And you say that that was intended to clarify how the objects of the association would operate, or at least to clarify that it would not be operating as a trade union. You say that was your understanding of 3A?
Yes, that's right.
The Rule 3A precludes the association, in effect, regulating relations between workmen and employers, correct? One of the things that an employer does is provide a safe system of work, correct?
Yes, they ought to.
And how is this rule going to operate with the existing rules?
Consistent with what I've said, that my view, looking at these documents, is that the inquiry was about whether or not this association would seek to do the kinds of things associated with being a trade union. Looking at this new Rule 3A, that the association aims to seek to regulate the relations between workmen and employers, that's a formulation about, seeking award regulation or this may well have been in the days beyond the common approach to enterprise bargaining, but doing the kinds of things that trade unions do, either under state or federal law, that is that they participate in the regulatory system, regulatory system of employment, things like serving a log of claims in order to create an award.
But why not just write back and say, well, it's not going to be a trade union because it's going to raise money for elections?
Mr Stolger, sitting here, I don't know, but can I suggest to you that one thing that may be worth looking at is whether or not this is a form of words somehow associated with the state industrial relations legislation at that time. I think it's that clarification that was being sought. Should this be an association or a state registered trade union? Those words look to me like they may have come from state regulation of some nature. Now, I don't have a direct recollection of it, but that is what, piecing together from these documents, I think I was dealing with at the time.
But if the concern that had been raised with you was that the association could be confused for a trade union, isn't the simple answer it's set up outside the union and it's going to raise funds for election purposes and operate a bank account to hold those funds?
Well, in the letter of the 15th of May, what's being asked for by the corporate affairs people is the inclusion of a new rule.
Well, that's your construction. The alternative construction is that you had proposed the new Rule 3A in your correspondence of 13 May.
And I'm not in a position to assist you with that further, and I don't think you're in a position to assist me when neither of us have the letter of the 13th of May.
Did you give any advice to Mr Blewett as to how the rule change would be affected?
The advice I gave to Mr Blewett is the advice you see before you on page 24.
Well, the effecting a change to the rules would require some sort of resolution, presumably a special resolution. That's right.
Well, this is a pre-incorporation amendment.
No, this. Well, what do you mean by that?
Just paragraph 3 of Mr Neil's letter. The Commission is prepared to incorporate the association with the existing rules.
Quite so, but
subject to receiving a written undertaking.
Mr Neil is proceeding on the assumption that there was, in fact, an association and that what the Commission was going to do is incorporate it, correct?
Well, the letter says, thank you for your letter of 13 May 1992 concerning the application by Mr R.E. Blewett to incorporate the above association.
Quite so. And in the passage to which you drew my attention, the third paragraph, the Office of State Corporate Affairs is saying the Commission is prepared to incorporate the association with the existing rules annexed. Subject to receiving a written undertaking, the association will amend its rules to include a new Rule 3A. The point being that Mr Neil is proceeding on the basis that there was in fact an association in existence, and what the Commission was going to be doing was to incorporate it under the Act, correct?
Mr Stolger, my reading of those words, and neither of us is Mr Neil, my reading of those words is the Commission is prepared to incorporate the association. That is the association for which incorporation is being sought.
Yes. And there was no such... I'm sorry.
With this change.
But there was no such association at that time, was there?
No, there was an application to incorporate an association, and I believe it's that association for which incorporation is being sought that Mr Neal is referring to.
Well, what Mr Neal was contemplating, and more particularly you were describing in your memorandum to Mr Blewett of 21 May 1992, was an amendment to the rules taking place within 30 days of the association being notified of its incorporation.
What's the question?
Well, I think I'm really picking up your comment earlier about whether or not this was a pre-incorporation resolution, and I'm agreeing with you to this extent that your memorandum to Mr Blewett of 21 May 1992 makes reference to a resolution that would need to be passed 30 days subsequent to the incorporation of the association. That's right.
Yes, that's right. So you're now referring to the last line of the third paragraph of Mr Neal's letter. Is that right?
No, I've come to your memo of 21 May.
Oh, you've come to my memo. Sorry, yes.
And
oh, I see. Okay. Sorry, I was on the wrong document.
You were contemplating that Mr Blewett would write, giving an undertaking that the association would amend its rules within 30 days of being notified of its incorporation to include a new Rule 3A. Now, my question was, did you give advice to Mr Blewett as to how the amendment would be effected?
I don't recall giving advice to Mr Blewett about how the amendment would be effected, but at this point Mr Blewett was obviously in possession of the rules.
You were causing, in effect, Mr Blewett to write, giving a personal undertaking to the Commissioner, the WA Commissioner of Corporate Affairs?
I think causing is not the right word.
Well, you crafted a letter for him to that effect.
My understanding from my instructions was that Mr Blewett and Mr Wilson wanted to incorporate this association. The clear meaning of the letter from Mr Neal is that there is an issue in relation to that incorporation. I've then provided advice to Mr Blewett about the resolution of that issue. Whether or not he accepted that advice or acted on it is entirely a matter for him.
Do you recollect whether the concern on the part of the Office of State Corporate Affairs also related to the fact that the words Australian Workers Union were included in the name of the association?
No, I don't believe so, and on the face of this correspondence that doesn't show, does it? You would anticipate, wouldn't you, Mr Stolger, that if there was more than one concern about incorporation, that it would be separately referred to in the letter of the 15th of May 1992.
Did you make an inquiry of Mr Blewett as to whether he had, in fact, or Mr Wilson for that matter, in fact caused the amendment to the rule to be effected?
No, having provided the advice, I wouldn't have.
No, I'm simply asking whether you made any inquiry subsequent to incorporation as to whether...
No, I did not. No, I did not.
You didn't follow up that matter?
No, I would have given Mr Blewett the advice, and then he and Mr Wilson and others, on my understanding, are involved in the association. It's then a matter for them.
Mr Wilson had by this stage moved to Melbourne.
My recollection is Mr Wilson moved to Melbourne in mid-1992. Sitting here, I can't tell you what date versus the 21st of May 1992. There may be something in your, the Commission's documents that helps clarify that, but I don't have that date in my mind.
Well, he certainly was physically in Melbourne at that time.
I can't help you with that, Mr Stolger. I know he moved to Melbourne in 1992. It may be that in one of the many documents before the Commission that date is clarified.
Did Mr Wilson have discussion with you about why he wanted to set up a fund in WA?
Not other than the ones that we've already gone to in our discussion during the course of this morning. Now the position
when this memorandum to Mr Blewett was sent on 21 May 1992 was that, so far as you knew, there had been no committee of management appointed or anything like that? You weren't aware of that?
Sorry, just repeat the question.
Committee of management had not been appointed to the association?
At what point?
When you sent your memorandum to Mr Blewett on 21 May 1992?
I don't know, and I didn't, apart from, as we discussed a little bit earlier today, advising about the requirements of an incorporated association. It had to have a minimum number of members, it had to have a committee of management. I didn't make further inquiries about how Mr Blewett and Mr Wilson then went about operationalising that.
The critical function of this association, as you understood it, was to enable funds to be received in a bank account that would operate so as to obviate the possibility of debate arising in due course about the ownership of those funds.
Well, we had that discussion earlier today, and you would recall what I said then,
Yes.
that I thought it was about regularising arrangements between a team of people associated within a trade union and going to run for re-election together, and election fundraising and the holding of an account into which elections funds raised for the election would be held.
Can I come back to Mr Wilson and his movements in 1992? At a certain point, at least, he was living in Cardigan Street.
Yes, that's correct.
And did you discuss the association with him from time to time?
No.
You had no discussion about it at all?
No.
You had discussion about his work, I presume?
Mr Wilson and I came to be in a relationship, as couples do in relationships. From time to time we discuss matters at work. If you had a particularly good day, if you had a particularly bad day. But no, we did not discuss the association. And whilst I would say, Mr Stolger, whilst this matter has come to assume a great deal of significance in the years since, at the time of these events and my provision of advice, it had no particular significance.
Which the association had no particular significance?
In terms of a busy legal practice, it did not stand out amongst the many legal matters on which I advised as a matter of particular significance. Or the significance it's come to bear as, happened as the years have gone on.
At some point during either the latter part of 92 or early 93, Mr Wilson started looking for properties for acquisition by Mr Blewett?
Yes, as I've dealt with in my principal statement and as is dealt with in the Slater and Gordon transcript of meeting, yes, my understanding was Mr Blewett was interested in an investment property, and it was to be one in which Mr Wilson resided.
And you prepared at some point a power of attorney in relation to that issue?
Yes, that's correct.
Now that's at page 51 of the bundle.
51 of the bundle under tab 2.
Yes.
Yes.
Now that's a document that, upon which your signature appears.
Yes, it is.
And your evidence, as I apprehend it from your statements, is that you have no particular recollection of whether or not Mr Blewett was in your presence when he signed it, but your evidence is that in the ordinary course of practice he would have been. Is that fair?
My evidence is I was a busy solicitor across the years in which I practiced as a lawyer. I would have witnessed many thousands of documents. I do not have specific recall of, each and every document I witnessed and the circumstances, which room, which desk, what I was wearing. I don't have that kind of recall, but I witnessed documents appropriately. I would only witness a document if the signatory was in my presence.
Do you recollect any occasion on which you departed from that practice?
No.
And what about your practice in respect of dating a particular document? Did you have any practice in that regard?
Well, you'd put the right date on a document.
Was there any central repository for original documents at Slater and Gordon, so for an original power of attorney? No. I mean, there was obviously Slater and Gordon had things like a secure wills section and that kind of thing, but no, not for a power of attorney. Do you recollect having a dinner with Mr. Blewett and others on the evening of 3 February 1993?
No, I do not.
You attended the auction of the Kerr Street property with Mr. Wilson in due course?
Yes, I did.
And did he have the power of attorney with him?
I don't have a recollection of him having the power of attorney with him, but having had the opportunity to look at the documents that are before the Commission, it appears, you may have come to a different conclusion, Mr. Stolger, but it appears to me he must have, because reference is made to it in the contract signed. Well,
what would have been the practice? Mr. Blewett, you witness the signature, and then what happens to the document?
Well, for this document, Mr. Wilson would have wanted the original, I would have thought, and a copy would have been kept at Slater and Gordon.
Right.
It may be he had a copy and the original was at Slater and Gordon. I don't have a direct recollection of it, Mr. Stolger.
In any event, you and Mr. Wilson went along to the auction. Did he have a cheque from Mr. Blewett?
I don't know.
Well, how was the deposit paid?
I don't have any recollection from the time about how the deposit was paid. I know that there are documents before the Commission that go to this matter, but I don't have a recollection.
Did you have any discussion with Mr. Wilson about where Mr. Blewett had come up with the money for the deposit?
I've had the opportunity, obviously, to refresh my recollection looking at the transcript of meeting between me and Mr. Gordon and Mr. Shaw, and as I summarise it, there is correct.
Now, which passage are you making reference to when you give that evidence?
There's a passage, let me just find it. Passage starting page 10, going over to page 11, that details Mr. Blewett indicating an interest in an investment property and the taxation advantages that accrue from negative gearing, and me referring him to Nick Stein Brown for some financial planning style advice, and then the paragraphs that deal with the purchase of the property.
Well, at the bottom of page, it's 11 in the middle at the top and 141 in the bottom right, you say, Ralph came here, looked at properties, and then I assisted with fixing up the power of attorney so Bruce could do the bidding. Mr. Gordon says, on the day of the auction with that power of attorney, Wilson attended, and I think you attended too. Yes, I did. Who did the bidding? And then bottom of the page, do you have any recollection of what happened with the deposit on that day? How was it paid? I don't have any recollection. bottom of page 142.
Thanks.
Well, I mean, the position must be that Mr. Blewett, he obviously didn't know how much the property was going to be knocked down for in advance. So he must have filled out the cheque on the day of the auction, is that right?
I don't have any recollection about the cheque. Not sure at the time I had any knowledge about the cheque. I think you'll find dealt with elsewhere in the documents before the Commission there's discussion about the cheque from either Mr. Blewett or Mr. Wilson.
In your witness statement, that's number 4 in paragraph 22, you say
Paragraph
that...
22, yes.
Yes, you say that you had no... you say I was not the solicitor handling that file, that's the conveyancing file. File was handled by the commercial department, which was a different section from where I worked. And you say it's apparent from the conveyancing file I prepared a power of attorney, etc. Now, you did have some involvement in the conveyancing matter. Was there some particular reason why you were involved in some aspects and not others?
Well, the conveyance was undertaken by the conveyancing paralegal, who's a person known to me as Olive Brosnahan. She's given evidence to this commission. She's obviously married in the years since and is now Olive Palmer. So she handled the conveyancing file. I've never done a conveyancing file.
No.
You are right, Mr. Stolger, that there were obviously some inquiries, I think it's 1 or 2 or 3 or something in that order, on the conveyancing file that I dealt with. I'm happy to go through them if you would like.
All right, well, why don't we go to page 93, behind tab 2. Now that's, is that Ms. Brosnahan's handwriting?
I don't know.
Not sure. But it is the case...
It's either her handwriting or I mentioned it to a clerical staff member who wrote down a note and gave it to Olive. I don't know which.
Well, you were clearly seeking a memorandum from Mr...
NOB is Olive Brosnahan.
I'm sorry, from Olive Brosnahan.
Yeah.
About the circumstances in which a higher interest rate is charged. That's presumably under the mortgage which was being provided by Slater and Gordon or some association or entity associated with it. Do you recollect why you were seeking that information?
I must have been asked by... I don't recollect. I don't have a direct recollection. Even at the time in 1995 of my discussion with Mr. Shaw and Mr. Gordon, I didn't have a direct recollection of these matters. But having had the opportunity to see the conveyancing file, which went into the public domain a couple of years ago, obviously I would have had an inquiry from Mr. Blewett about what it meant, what a reference to an interest rate meant or something like that. And so I sent or had caused someone else to send a note round to Olive.
And then on page 97 is the memorandum you'd requested.
Yes.
And I take it you would have communicated that information back to Mr. Blewett or Mr. Wilson?
Yes.
Because Mr. Wilson from time to time was also making inquiries about this matter?
I think the file shows that.
Yes. And you certainly understood at this stage that Mr. Blewett was obtaining a mortgage from Mr. Rothfield to procure part of the purchase monies for the Kerr Street property?
At the time of the requesting of the memo from Olive, yes.
Yes. And when did you become aware of that information?
Oh, I don't know. I don't recall.
If you come to page 98, now that's another document from the conveyancing file. Did you have a discussion with Ms. Brosnahan about the costs and the writing off of costs?
Yes, I did.
And typically she would come to you as a partner with some knowledge of the matter to discuss whether or not Slater and Gordon would write off the fees. Is that right?
It was routine at Slater and Gordon, as I think I described to you earlier, with the industrial unit developing relationships with trade unions, trade union officials, with Slater and Gordon seeking the referral of plaintiff personal injury work. It was common at Slater and Gordon for fees to be, for something routine like a conveyance, for fees to be wholly or partly declined.
Page 99 is a letter of 17 March 1993 to Mr. Wilson.
Yep. Sorry, do you remember Mr. Biggie?
99. Did you have discussion with Mr. Wilson about this letter? Do you recollect?
No.
Have you seen the letter before?
Not other than in the Commission's documents.
Did you see it at the time?
No.
The letter makes reference, among other things, to the fact that the principal sum advanced under the mortgage is $150,000, and then deals with default rates of interest at the top of page 100, and at page 101.
Oh, page 100, yes.
Then if you come through to page 101, mortgagee requires prior to settlement an original insurance policy or certificate of currency. And when you read that paragraph, does it refresh your memory you had discussions with Mr. Wilson about these matters?
No, it does not.
Because what the mortgagee required was yes, a certificate of currency from an approved insurer noting the interest of Mr. Rothfield as first mortgagee for not less than $200,000.
Yes, that's what the document says.
And that's something that you attended to yourself?
I don't believe I ever saw this letter. Separately on the conveyancing file, you're right that there are a number of file notes, etc., which seem to indicate the certificate, or what's it called, the certificate of currency, is that right?
Yes.
Yes, the certificate of currency was being chased from Mr. Blewett. That Mr. Blewett needed to obtain and provide a certificate of currency. Presumably that's related to completing the conveyancing transaction and the matters associated with the mortgage. The conveyancing file appears to show that that was being sought, and I did obviously assist at that point. So
is the answer to my question yes, that obtaining this certificate of currency is something that you attended to yourself?
I obviously assisted with it. Where I'm disagreeing with you, Mr. Stolger, is I didn't see the letter you refer to. There's nothing in that letter that caused me to assist with obtaining the certificate of currency. If you look elsewhere on the conveyancing file, I think there's some back and forth that's documented between Olive and a legal assistant who worked with me about the certificate of currency.
And that file note, are you referring by that to the file note at page 114? You may not be, I'm just asking.
Yes.
So that's Ms Brosnahan's handwriting,
Yes, it is.
and she had left a...
Oh, well, I presume it is. I can't give evidence about whose handwriting is whose, but given it's signed by her.
Well, I'm sorry, please.
I think
given
it's not actually
no,
signed by her at the right day. It's the 19th of January 2013. She's identifying the document.
Oh, I'm sorry. Okay.
Just so that you're not under any
Yes.
misapprehension.
Yeah.
But anyway, this file note records, it would appear, a conversation with Mr Wilson, certificate of currency through, I think that should be Commonwealth Bank. Ralph spoke to Julia Gillard, spoke to Ralph this morning. He was chasing up Commonwealth Bank. And then if you come to the next page, 115.
And then under that's to Julia, not in, left message for her to ring me or something like that.
Yes. And then if you come over to the next page, page 115, CBA wrote to you on the 22nd of March 1993 saying, in accordance with your request, we advise the buildings are insured for $200,000, the Commonwealth Bank of Australia insurance scheme, and the interests of Mr Rothfield as first mortgagee has been noted. So it would appear that you chased up the Commonwealth Bank re-getting that certificate of currency.
I either chased up the Commonwealth Bank or I chased up Ralph to chase up the Commonwealth Bank. I don't know which.
Well, the letter is addressed to you and says, in accordance with your request, dear madam. Certainly
Yes, but
appears to be responsive to a request made by you.
You may well be right. I was just looking at the document before that says Ralph spoke to Julia Gillard, spoke to Ralph this morning. He was chasing up Commonwealth Bank.
Can you come back to page 103?
103?
Yes.
Is this a short point you're on, Mr Stodger?
Yes, I'll raise a short point anyway and then perhaps come back to this after lunch.
All right.
My only question is, had you seen this letter, or did you see a copy of this letter before it was sent?
No.
Very well. Suitable time to adjourn?
Yes, Commissioner.
The hearing will resume at 2 p.m.